Next up, we have Bill number 2373 by Senator Mack, an act relating to criminal procedure, sentence, and execution. Execution. Senator Mack, welcome to the committee.
Hi,
you may
Chair
proceed.
Hi, Chair Coyne and members of the Judiciary Committee. Bill 2373 is an aim at fixing our probation system as it currently exists. Rhode Island's probation system is one of the harshest in the country. On average, our probation terms in our surrounding states are a little bit over 4 times that of Massachusetts and a little bit over double that in Connecticut. These harsh and unwarranted probation systems have a devastating snowball effect. And a 2015 study found that people, though the current bill, as stated, says that folks can be held no longer than 10 days, excluding weekends and holidays, it was actually found in 2015 that folks were held on average of 31 days. As you can imagine, 31 days being held at the ACI can result in devastating snowball effects, including loss of job, loss of work, loss of income. It could also impact childcare, continuity of progressive progress inside of one's own community, and it also prevents stability. This also comes at a cost to the taxpayers, holding someone before they have right to a fair trial for up to 31 days before they are tried in court for a parole violation. This also leads folks, as you can imagine, a loss of work for 31 days is make or break for many people who live paycheck to paycheck. And this results in some folks who might take a plea deal rather than see out the process of a parole violation and a hearing because they cannot face or afford to miss up to 10 days of work, excluding weekends and holidays. And again, that is, it's been found that there's an average of up to 31 days. Some other facts about why we need this parole reform right here in Rhode Island is that there is no evidence that shows that a longer parole period leads to any decrease in prison or any increase in prison recidivism rates. I can share some of these numbers with you as well. And there are going to be some folks here from the coalitions who I've been working with on this bill who will speak about their own personal experiences. Again, as the law currently states, folks can be held up to 10 days and do not have any assurance that that bail will be set. This would allow a court to set bail and allow that person to go about their day-to-day activities, continue to be a breadwinner inside their families, provide childcare, and be a member of the community until they are held for a fair trial. And with that, I will take any questions on 2373.
Thank you. Any questions? Yes, Senator Archambault.
Yeah, thank you, Senator. Sometime back, a long time ago, almost 20 years ago, I argued that the violation process in Rhode Island, which looks backwards, not forward. New criminal charge, you're innocent until proven guilty, all the rights that we have under the Constitution. So you are presumed innocent until proven guilty, and it looks forward. Violation hearings look backward. They say, look, you had your day in court, now you created a violation, and the standards of proof are very different. The standard of proof looking forward, beyond a reasonable doubt, it's as high as those ceiling tiles. The standard of proof on a violation hearing is, reasonable likelihood that you breached the peace. It's like down at the bottom of the carpet. So there's a problem somewhere in there with people who may be accused of a new crime and then fall into this lurch where it's just how much time. And I get that. It always bothered me. So the spirit of this, I think, is in the right vein. I think that constructively, though, when it presumes that everyone should be released on bail, you're losing the people that fall into the violent crime category, or the people that may be on a huge sentence, 20-year B&E, and then he commits a couple other crimes, and then he gets out, and suddenly he's accused of a violation. Under this statute, he'd be assumed to be, he'd have to be given, it says shall. So the terms of art is, you're bright, it's may or shall. May is permissive, shall's mandatory. The language you've redacted is the court may order the defendant held without bail not exceeding 10 days. Sometimes they're not held. In practice, the past couple of years since COVID, more and more people aren't being held. But there was a long-term mindset which would hold people all people. And I never agreed with that. So that may, I think, was, I won't say misused, but it was more of a shall in the past. But the issue I would have, I just think it needs some tweaking. I think the spirit's good, but the issue is that if you say that everyone shall be released on their own recognizance, you're going to have a whole category of people daily in these courts with violent crimes that are offenders who would have to be released under this, and that you don't want. So I don't know if it's another clause, another sentence, something that could capture that category with what you're trying to do here. It could make the thing workable. Does that make sense?
Yes, can I follow up?
Would you like her? Yes,
Yes,
please.
Yes, and so we did take some of that feedback from last year from its introduction. We did remove the carve out for nonviolent crimes, and this is only for parole violations and not for any new offenses. So this is for folks who have violated their parole, so that they will be able to have bail set opportunity. The current bill language does not allow for that, and so we did take that feedback from last year to ensure that, and some of the advocates will be able to speak to that as well, that we did make sure that we didn't include folks with violent offenses, because that was some of the feedback that we got last year. But I can make sure that's more clear in the legislation, and happy to work with you on that wording moving forward.
Let me follow up with it just and respectfully, because I understand what you're saying, but this language doesn't do that. It's not just parole. It's parole, probation, any type of violation, what we call 32Fs, either technical because they didn't do something they were supposed to do, or substantive because they pick up a new charge. I know, because I'm in these courts every day doing this stuff. This is what I do for a living, prosecuting and defending it. There's a whole area here of people who commit violent stuff that it would go just the way I'm telling you. So I want to help you. I like the spirit of the bill, but it needs another clause that's going to add a carve out for the people with the violent stuff. Mike knows what I'm talking about. So I like your open-mindedness. I mean, it's workable, but it just needs something to cover that category. If people are telling you, oh, don't worry, it's just parole, and they're wrong. That's not accurate. I like your open-mindedness.
And I believe Senator Mack said that she would be happy to
Yes.
work with you on that,
Thank you
too.
for that,
So,
Yep.
yes, Senator Reptag.
Senator Mack, you said at the beginning of the testimony that Rhode Island has the worst bail statute, or?
Oh, no, one of the harshest probation systems in the country. We rank currently third with the most amount of months that someone is on probation.
Sure. Do you have any documentation? I know NCLS was here today, and they're a great source. If maybe you can pull that, where you found that information, to share it so we can see where Rhode Island ranks under the guise of the probation issue. And the other issue that I'm probably going to agree with Senator Archambault, I have one article here. It says, man charged with sexual assaulting woman at Warwick subway. And this was April 17th, 2015. I'm not going to mention the person's name because I'm not going to glorify him or give him some notoriety. It says this person had a lengthy criminal record. A search of court documents revealed charges included in part burglary, assault, shoplifting, obstructing a police officer, and forgery. Now, that was in April of 2015. When you go forward to April 6, 2022, Providence police convicted sex offender tried luring girl 14 with lost dog story. Same individual. So are these the individuals that we want to give them no bail to allow them back out on the street like a revolving door? I mean, this is very concerning to probably most of us here. So.
Yes.
Yes, Senator Mack.
Yes, and again, I know that we got that feedback last year, and I'm happy to make sure that we tighten up that language to exclude some of these situations that you're alluding to. The goal of this is to make sure that folks who are doing everything right while they are, and who have no prospect of reoffending, who are parents and caretakers, are given the due course of the law and able to have bail posted and to continue about their life until they have a right to a fair trial. This does not include folks who are violent offenders and folks who have a high risk of reoffending. So again, I'm happy to work with this committee on tightening up that language so that we can ensure that this is impacting the folks that we want to, and it ensures that there's no job loss, no loss of childcare and continuity in homes, and that we are not opening the floodgates for some of the offenders that you all have mentioned today.
Thank you. Thank you very much. if there are no other questions, thank you very much for your testimony.
Yes, thank you.
And with that, we'll proceed forward with the list of witnesses we have. Just a reminder that witnesses will have 4 minutes to testify, and if for some reason you have more to say, you can feel free to put it in writing and submit it to the clerk or slegislation@rhodeislandlegislature.gov. With that, I'd like to call up Richard Ferruccio. Jordan Goyette says he's written only. Haley McKee. And I have Hannah Stern, but she says not speaking. Jordan Jace. Is Jordan? Oh, perfect. Okay, great. Welcome to the Committee on Judiciary.
Thank you.
If you could state your name and who you're representing, and then you may proceed with your testimony.
Sure, can you hear me? Okay. I'm Richard Ferruccio. I'm the president of the Rhode Island Brotherhood of Correctional Officers. Just so you understand where my comments come from, they're based on 38 years of working as a correctional officer in the system and someone that's been pretty actively involved in a lot of this. I am here on behalf of the Rhode Island Brotherhood of Correctional Officers to voice our strong objections and concerns regarding this bill. House Senate Bill 2373. This act, as stated, requires bail for defendants coming into court as alleged probation violators. We believe strongly, and I believe strongly, that this legislation is dangerous and irresponsible. And I don't use that word loosely. The Rhode Island criminal justice system routinely provides, as Senator Mack said, actually light criminal sentences that are heavy on probation. See, there is a significant difference. If you look at the Rhode Island incarceration rate, it's something that should be taken into consideration by people when they're looking at the criminal justice system. We are always in one of the lowest states for incarceration. I looked up numbers before I came here. Rhode Island right now is at 156, Maine 145. Number one is Massachusetts at 108. On the flip side, the incarceration is per 100,000. The Louisiana incarceration rate, which is the opposite, they don't have a lot of bail, but they put people in prison and a lot quicker. They're 684 per 100,000. So keep those things in mind when you're looking at what's taking place. Senator Mack is correct. We are one of the more generous states because if you're on probation, you're back on the street. It's not something the Brotherhood has ever objected to. This legislation is dangerous and, like I said, will result in, I think, negative consequences. Senator Archibald, you got it right. If this was something that we're talking about a technical violation, I'd probably be sitting here testifying in support of it. But that's not what we're talking about. Senator Raptakis, you made mention of the individual that just got arrested. I'll actually say his name, not because I want to glorify him, but people need to understand, and he should be ashamed for what he did. His name's Sean Turgeon. You know, that crime that he committed in 15, he just got out and tried to entice a 12-year-old little girl. Sean was arrested Tuesday night. He was charged with enticement of a child, failed to register as a sex offender, possession of cocaine. According to Thomas Verdi said that the victim is very fortunate, and we're grateful to the witness who flagged down because it might possibly have saved her life. If this bill was in effect, Mr. Turgeon would be up for bail. I don't see that as something that should ever happen right now. So for these reasons and maybe many others, but I'm going to hold myself to the 4 minutes, which I don't want to get corrected. We are here and raise our strong objections to this bill. Thank you.
Thank you for your testimony. Do we have any questions or comments for the witness? Seeing none, thank you very much. Haley, you're up next. If you could state your name and who you represent, please.
Good evening, Chair Coyne and honorable members of the committee. My name is Haley McKee. I am here on behalf of the Super PAC, and I should also mention as well that I am a person who is currently on probation in the state of Rhode Island. I was one of those people who they've decided to hold on to despite reform. That would be another bill, so I'm not going to go too far into that. However, I haven't been in a circumstance just because I've been fortunate enough to be given a lot of opportunities since I've re-entered society. So I am here in support of S2373 this evening, and I will keep it brief. And I just want to touch on a couple things I've seen through a lens of working in the recovery field since I've returned home from prison. So at one point up until very recently, I ran an intensive outpatient program at a medically assisted recovery clinic. And, you know, it was sad to currently see people cycle in and out. So you'd have somebody who was in your care who was really trying to achieve some sort of recovery progress, and then they'd, you know, be coming to groups and participating and doing all of the things and really trying. And then they'd fall off the radar for a couple of days. And the first step that you go to take is to look, you know, at the DOC website to go and see if this person's recidivated. And unfortunately, that's oftentimes the case. And the feedback that you hear from people after that happens is there's generally some loss after that week or 2 weeks or 4 weeks in these conditions while they're just simply being held. Usually you hear things such as, I lost my recovery housing, I lost my job, I was discharged from X, Y, and Z programs because I was off the radar for a few days. So it just puts somebody unnecessarily, I feel, in like a tailspin, and they lose a lot of progress that they've tried so hard to work for. Additionally, now I work in public health research, and when people who are regularly engaging with, who are either actively using an early recovery or trying to achieve some form of recovery, again, these people go missing. When they come back up on the radar, it's, I was held for not paying a fine, which we'll be talking about in a little bit. You know, it can be a very small infraction that can have a very strong impact negatively on a person's life and really lead to some serious, significant setbacks. So for those reasons and many more, we support this bill. So thank you very much for your time.
Thank you for your testimony. Any questions? Yes, Senator Archambault.
Yeah, thank you. And Haley, if it comes, I said it earlier, if it comes to technical violations, just like Richard just said a minute ago, if it comes to technical violations where somebody could get in compliance, I think there should be a presumption to bail, and the person should be given an opportunity to get themselves in order. And, you know, that dovetails with the pretrial services and everything that Mike Delauro talked about earlier. My concern isn't with any of that stuff. It's with, you raise all these valid points. It's with the cases where somebody is a 32F for a violent crime under this language. They're out. There's just, you're going to release them. That shouldn't happen. And that's so you follow me? There needs to be a little bit of a tweaking here, and then we might have it all.
Yeah, I hear where you're coming from, Senator. I'm just here. I'm not an attorney, and I'm the furthest thing from an attorney, and I'm just here to advocate from, you know, experience working with a population of people who are oftentimes impacted by these kinds of existing laws.
You're a passionate advocate. I appreciate it.
Thank you, Senator.
Any other questions for the witness? Seeing none at this time, before we ask for Jordan's testimony, Mr. Clerk, could you please record Senator Quesada in the affirmative on the votes that she missed?
Yes.
Thank you. Next, Jordan, welcome.
Hey, hi everybody. Thanks for having me here. My name's Jordan Jace. I'm a part of the Behind the Walls Committee. We're a group of people who've been locked up. We're a family inside who are, looking to make our prisons more humane. I'm in support of the bill, and there's a whole bunch of reasons. Let me go through my scattered testimony to find them. So just to start with, probation doesn't keep people out of trouble. I think it actually makes every part of their lives a potential source of trouble. I don't think that the example that Mr. Ferruccio gave is really one that gets to the point. The vast majority of these people are people who are trying their best. They have work, they have homes, they have families, and it doesn't really make sense to me to lock somebody up for 10 days, completely destabilize their lives. And 10 days is in rule, but people wind up in there for months. I don't think that's giving people a fair chance. We haven't addressed like the standard of proof for getting your probation violated. Disturbing the peace is incredibly flimsy, and a lot of times people are accused of things, and because it's a violation, even if it's something that has not been confirmed that they've actually done it, they're locked up. They're spending time. And again, this is ruining people's lives. Honestly, my points really do cover those bases, the impact on someone's housing, on their work, on their family. And then additionally, if they are in recovery, if they are trying to work through something, I don't believe our prisons are really places for people to be rehabilitated. But yeah, thank you.
Thank you for your testimony. Any questions for this witness? Seeing none at this time, thank you all for coming and testifying. Next up, we have David Chaves, Trent Manning, Do we have Trent? Ron Doyle? Celine Means? Rachel Bishop? Welcome to the Committee on Judiciary. Again, if you would state your name and if you represent an organization. And again, you have 4 minutes for your testimony. We'll begin first with, is it David? Yes.
Okay, this is better? Okay, thank you. So my name is David Chavez. I represent Behind the Walls Committee and also Black and Pink. I am speaking because I was a violent offender at one time. I spent 20 years of my life in jail. Within them prison walls, I did better myself. I came out. I'm in college. I'm studying mental health social work. During this time, I become a caretaker for my mother. I bring my lady, which is epileptic, to her hospitals, where she got to go to appointments. I do the same thing for my mother. I work 2 jobs, part-time, while I'm in college. I'm also a mentor. And I fear, because it has happened to me. I'm driving, whatever the case is, cops see me, they pull me over. They say, we're looking for somebody similar to you. Do you have an ID? This car, we're looking for a car similar to this. And that scares me because I have 12 years over my head and I'm doing the right thing. And I know that if they wanted to, they can lock me up, put me away for 2 or 3 weeks. Within that time span, these people that depend on me, in a way, is showing them that, okay, maybe he didn't change, he got locked up for this. Now they have to rethink the way I am. My mentee, she will look at me different. It doesn't just affect me on a personal level, it affects me on a social level. I have built trust within my family, I've built trust within the community, I am moving forward in life. So I do understand the violent aspect because I was a violent offender. 2nd-degree murder, assault while in prison, causing a riot. I have done that, but I have changed my life. So when they do pull me over, they do run my record. When they do run my record, I get put in cuffs, I sit in the back, I get searched, but I am not that person no more. And it affects me because in the back of my head, I'm thinking, they're gonna take me, put me in jail, I'm gonna sit for 2 to 3 weeks. During that time, I lose my jobs, I get kicked out of class, or the process that I am making does get taken away from me. And I do respect the decision that, yeah, there are certain crimes, like you mentioned, that must be addressed. But I am an example of that is change. I am working towards helping people. I have been putting back into community. I have been doing everything I can. And it scares me that I have 12 years over my head. During these 12 years, on the routine stop, which I do get stopped, I believe it's because they see me, they see my tattoos, the way I was, they run my background, they run my plates, I get pulled over. They just might take me and be like, oh, this and that, and take me because it might be somebody that they're close to looking for, which is an excuse that I do receive a lot. We're looking at somebody similar to you, to your description. We're looking to a car similar to yours. And like once, twice a week, I get pulled over. And that does scare me. It scares my family. I got pulled over with my mom one day. I got pulled over with my lady. I got pulled over to take my mom to the hospital. And during that time, I'm handcuffed and I'm put in the back. I'm bringing her to a doctor's appointment. And I'm thinking, if they lock me up, how is she going to get there? Who's going to get her? Who's going to pick her up? I'm her caretaker. I am doing this. So it does scare me. This bill does affect me personally, an aspect to where it would take me away from that. Like I said, I have been working. I have jumped through all the loops. I have done everything. I have no complaints. I am proof in a way that it can work if it is done properly. Like I said, now I'm a mentor to a young teenager. I'm helping her. This, like the bond, everything I'm building with her, a lot of things could be destroyed by just that distance. How can I tell you that to do good? How can I be an example to you if all of a sudden I am taken away and locked up? They won't see that, oh, well, the trial, they won't see that. They will just see, oh, he's locked up. He's in jail. The way they view it is like, oh, he's in jail. They're not really looking at the laws. They don't really understand this. So this affects me personally.
Thank you. Thank you for your testimony. Yes, Senator Rep. Tactus.
Quick question. You just shared with us a story. But when you, say if you were pulled over and you're in the back of a police cruiser and you're taken to either the police station or to the ACI, were you being charged with something? Did they charge you with something? Because, of course, they should not hold you. If you didn't get charged, you should not be held at all. You should be allowed to go home. Is it the issue with, say, if you were charged with an event that occurred? Is it because the judge doesn't see you within that? Should we speed up the issue where a judge should look at your case within, like, say, 48 hours or 72 hours and not 10 days where you'll be sitting at the ACI. So I'm just trying to clarify what you exactly told me. You told me a great story, but if you haven't been charged, you should not be held at all.
Yes, I understand that. That is a good theory. Realistically, because I am on probation, it is skeptical of how they could just they could say I'm refusing or something like that. I have been, polite, being as I can, but I have also instances where I run into officers that really don't want to hear. They be like, oh, well, you got a record. Let me check your car. I'm gonna look for guns. I'm gonna look for drugs. Now I'm handcuffed in the back and I'm getting searched. Obviously, I don't have nothing, and if I am taken to the just say if they want to lock me up, I would have to wait these 10 days. And during it, even if I'm not, because I have seen that happen with friends, and this is why I'm afraid, and it happens. I fortunately have not gone through that, but I do get very close to it, and that scares me because, like I said, I have got pulled over while going to the hospital, and that frightens me. I just want the bill to work in the aspect of if I am responding, if I can be seen within a certain reasonable amount of time, not 10 or 12 days, because during that 10 or 12 days, a lot happens.
I believe Senator Archambault has a question.
Yeah, thank you. First and foremost, you're arguably probably exception to the rule. God bless you. You've done well. You've come so far with everything. I hear what you're saying about your fears. I get that. And I said earlier, I think the system itself needs to be revamped. I've said that for my whole career, for 20 years. I've argued with guys in the AG's office, senior guys who are no longer there. But let me stay focused on point here. Even though you've had this violent past, you've done all these remarkable things since then. You're helping everybody. You're building your treasures in heaven now, right? You're on that road. So, and God bless you for it. If you're stopped for something, and it's, we'll never Monday morning quarterback law enforcement, but if you're stopped and no crime results from it, you're okay. You're going to be nervous, and you're going to have anxieties, but if there's a new charge, what my focus was, and what I said earlier to the sponsor, to Senator Mack, and to Haley, and to Richard, there's a piece missing here. If you were charged with a minor offense, right, you're not going to they're not going to send you back in for a minor offense. If you're charged with a major offense, which isn't going to happen to you, right, if it was something like a larceny or something else, right, yeah, you might be facing 30 days, 60 days, 6 months, which could cause the fabric of your life to fall apart, which is why your fear is at the forefront of who you are, and it won't happen to you. It's not going to happen to you, right? But it's the crimes, let's put you aside for a second, it's the crimes that are violent in nature that are the violations on somebody in the past. That's the piece that's missing here. So what I'm suggesting to you is you could have all of this and add that piece and protect the state from those kind of people and be all right. There does need to be a change. This change is the spirit of it's good, but it just redacts and takes out any potential for you follow me? Mm-hmm. I do appreciate your testimony very much, and you be commended.
Thank you, Senator. Any other questions or comments from committee members? Yes, Senator Quesada.
It's not a question, but thank you, Madam Chair. It just, it's very easy, and I'm sorry to my colleague, Senator Archambault. Sometimes it's easy for us to say that, but you have to be sitting in their place for you to be able to realize what they go through when police stop them. I really think it's just when you are somebody of color and you look like somebody they're looking for, that can happen many times. And I understand what you're saying, and that is true. And that's one of the problems, because he had 12 years. And they're not going to look at him. They're looking at his record. They're looking what he did in his past. They're not looking the person he is today. And that's the problem. And I really think that's the problem, because he changed his life. He's doing good for his community. But the judge or the police who stopped him can say, well, he did all these bad things many years ago. He may be doing the same again. We're taking a chance to let him go or whatever. Or he looked like the person we're looking for. And it's so many people who look like us outside. And that sometimes is a problem. And that way I do understand. And thank you for being here today.
Thank you, Senator Quesada. Senator Archambault.
Yeah, Senator, just to clear up something for a minute. the bill, that's not what we're on the bill. I agree with you 100%, sister. That shouldn't happen. That's racial profiling, targeting. There've been all these studies done. We need to clean that up. We need to stay vigilant. The only way you're going to get rid of that is to stay vigilant with education on cops and society and everything. You may never get rid of it, but I'm an optimist. You got to stay on it. That's not what this is about. People who commit crimes and whether or not they're granted probation, parole, automatic. Strike that. Probation. Strike that. Whether they're granted bail for a probation violation. This bill changes it so you're giving it 100% even if it's a new violent crime. That's our focus. The very articulate gentleman was given his life experience, which was important to it.
May I say something briefly?
I think we are finished at this time and need to move on to the next witness. Celine Means.
Hello, I'm speaking on behalf of RICARES, Rhode Island Communities for Addiction Recovery Efforts. And I did submit written testimony, and so I will be a more concise version of mine. But I did want to speak to some of the points, is that people are being locked up for no reason. I also want to mention about how one thing that this would help is one reason why people end up in the ACI for 10 days and then end up for 30 days is because there's such a backlog on probation officers. They are overworked. And this actually would help alleviate them. It would help alleviate the overcrowded system. I'm actually going to speak out to this story of my coworker, Kevin, who couldn't be here, but his brother was at a Subway and was arguing with a guy, the staff member, to put on gloves, health reasons. The police got called on him. His brother then ran and found out that he was on probation. So he was put into the ACI and locked up for 30 days. And after he left, he found out that there were no charges filed against him. Also during that time, Kevin and his two brothers were actually taking care of their mother, who was in at-home hospice. She only had 2 months left to live. And of that, his brother was stuck in the ACI for no reason. And he came out to find out that there were no charges and that his mother had passed away. And this is a story we hear often over and over at Behind the Walls Committee of people who are given technical violations by their probation officers and then find out that there's no actual charge. And that's the point of this bill, is to make sure that people are not stuck in the ECI for no reason, especially especially also just for all the reasons that certainly people have repeated over and over about the effect of being put aside for 30 or 10 days and how that has effects on people's health. That's really all I can say at the moment. Any questions?
Thank you. Any questions? Yes, Senator Archambault.
Yeah, thank you. Thank you for your testimony. I just want a couple of quick points. You testified the other night and did a fine job, and none of this is personal. I just want to stay on the bill. You say people don't get locked up for no reason. People get locked up for no reason. People never get locked up for no reason. That never happened. 22 years of practice in those courts, 5 days a week, all the time. I've never seen anyone locked up for no reason. So I say that respectfully, and we don't need to dwell there. There's a distinction that has to be made. You nailed it in your last point. Technical violations, a technical 32F versus substantive violation, a substantive 32F. The technicals, I agree with you wholeheartedly. There should be a presumption that you're going to get bail, that you could have a chance to comply, let the court review it in a short period of time. Even if it seems like the technical, you didn't do your batterer's intervention classes, you didn't complete the alcohol classes for the DUI, you didn't do something else you were required, you didn't pay restitution, right? I will say in practice, I think the majority of judges that I've been in front of do give people chances, first chance, second chance, but it would be nice to have that safety net in the law so that if there is a technical violation, you're not automatically sent off. That's a good thing. I'm with you. It's the substantive violations, when you commit the new crime that's violent. Just keep an open mind to that. Don't be resistant to it. If there's language that is crafted that adds a clause to this, you get something really good that'll take care of all aspects. You hear what I'm saying? It's close.
Thank you, Senator. Any other questions or comments? Seeing none, thank you for your testimony. Next will be Rachel.
Hi, my name is Rachel. I'm testifying on behalf of the group Showing Up for Racial Justice, the Rhode Island chapter, in support of the bill. We support this bill because we think it's a vital step towards making Rhode Island's probation system more just and our communities safer. I will say our organization is one that brings white people into anti-racist movement, and our network in Rhode Island is over 1,000 people strong. So you've already heard many times tonight that Rhode Island has one of the most excessively harsh and ineffective probation systems in the country. And technical violations such as missing an appointment and failing to report an address change, those should not, I agree, land people back in prison. We all know sometimes the bus is late, sometimes the sitter cancels. Our pandemic economy makes avoiding those violations almost impossible for many people. I think we can all agree re-imprisoning those people, breadwinners, caretakers, folks who are important in our community, it makes our communities less stable, makes them less safe, not more. Tonight, some folks have used fear-mongering about repeat offenders to support the status quo of refusing bail also for substantial violations. And we ask that you not allow yourselves to be misled. As Senator Mack has said, long probation sentences are not, in fact, shown to reduce recidivism. Denying bail to people who are charged with a new crime simply creates a system that is effectively guilty until proven innocent. So what happens, in effect, is that people are now forced to choose between a week, a month in prison, awaiting trial, or just accepting a plea deal, having more probation. And as Senator Quesada said, the potential for discrimination in the system, the potential for coercion in that system is very evident, and it happens. We know that Black and brown neighborhoods are over-policed and they are under-resourced. So the way the system works currently is set up to re-ensnare folks in the system. If you are innocent, eventually, what do you do? If you're going to lose your home, what do you do? These impacts all fall disproportionately on Black residents in the state. 1 in 6 Black men is on probation compared to 1 in 20 of the general population. And that inequity has very massive ripple effects. It means Black children are more likely to be separated from their parent or become houseless. It means Black elders are more likely to lose their caregivers. It means Black communities are more likely to lose people, have their wealth stripped from them. And because people on probation are also barred from jury duty, this also means that Black, Latinx residents, they're underrepresented on Rhode Island juries. So when we talk about systemic racism, this is in fact an issue of systemic racism. This helps the cycle of racialized punishment just keep producing itself. The legislature, I really believe, has a chance to interrupt this cycle with this bill, and we would urge you as SURJ to move forward with it and make sure that our state can go in a more safe and a more just direction. Thank you.
Thank you for your testimony. Yes, Senator Archambault.
Well, you knew I had to comment, right? I mean, I'm probably one of your most unlikely advocates in your eyes, right? But I sit in the courts weekly dealing with this stuff all the time. When you say that it's fear-mongering and it's about, trying to garner some type of misrepresentation about 32Fs. I didn't come in here tonight sitting up here thinking I'm going to argue about 32Fs. I'm talking about it with you because I know it. I know it better than you know it. I know it better than the senator knows it, only because I deal with it all the time. I don't know energy like Senator Oyer. I certainly don't know municipal government like Senator Rogers, and I could go on and on and on. Wills and trusts like Senator Lombardi. This is my wheelhouse. And if you're not hearing me, I want to help you. There's an aspect here that's missing. Focus. If you focus on carving out a piece that says if you commit a new crime of violence, you might have what you want. But if you come in and say, scorch the earth, that the whole bill, everything we're saying is horrible, you miss the entire point. Hear what I'm saying.
Thank you, Senator. Any other questions or comments? Seeing none at this time, thank you very much for your testimony. Next up is Anisha Alls. Mike Delauro, I know you signed up for questions only. If you'd like to come up, if anybody has any questions. Brandon Robinson. Welcome to our committee. If you would state your name and who you represent before your testimony, and just a reminder, you have 4 minutes. Welcome, Anisha, you may proceed.
Thank you. Hello, my name is Anusha Ellis. I am a staff organizer at Direct Action for Rights and Equality. I organize with the Behind the Walls Committee, and this is the group of people who drafted this bill. So we drafted this bill because our community is so heavily affected by probation. And as Senator Mack said, we have one of the worst systems in the country. And Dick spoke to this earlier and said that because we have low rates of incarceration, we should consider our system generous or lenient, but actually the way that probation functions in Rhode Island is as a ongoing cycle that traps people. And one of the ways in which it traps people is by so easily allowing people to be reincarcerated that people end up taking plea deal after plea deal after plea deal. And some of our other members are going to speak to that today, of having gone through that, being forced into plea deal because they could not afford to go to prison for those 10 days or longer waiting for a violation hearing. So I just want to point that out, that sometimes we consider ourselves a progressive state in that our rates of incarceration are low, but the way that probation functions is actually an ongoing trap that keeps people chained to the system. Our members, many of our members are on probation. My loved ones are on probation. My partner is on probation. So I'm speaking today not only as a representative of DARE, but also as somebody who has many loved people, many loved ones who are impacted by this, and with somebody who lives with the knowledge that these people can be snatched up at any point for being in the wrong place at the wrong time. And respectfully, Senator Archambault, I know people who have been arrested and locked up for not having done anything, for being considered guilty without having had a chance to be heard. And that is exactly how our probation system functions. Under Rhode Island's current practices, once the cuffs are on you, if you're on probation, you are most likely going to be taken to the ACI for at least 10 days before you even get a violation hearing. So I just want to emphasize, it doesn't matter how small the charge is. It doesn't matter if there's no evidence at all for the charge. It doesn't matter if they don't even end up bringing the charges against you. And those 10 days can stretch on for months, especially now that the courts are being backed up with COVID spikes. So last month, one of our members, I watched this happen in court. One of our members, Jose, was arrested. He was arrested on a falsified police report of a domestic disturbance. The person who filed the police report attempted to undo the damage, but it was too late. He was already in the system. He was brought to court along with the other probationers, and we watched as the judge sat there and denied bail over and over and over again to every single person who came up. He wasn't even looking people in the face. It was a completely dehumanizing experience for the people going through that. And he had the words coming out of his mouth to deny Jose bail, and Jose interrupted him and said, "Can I speak?" And he convinced the judge to grant him bail by forcing him to listen to the details of his life and what had occurred. And because the judge was forced to listen, was sort of jerked out of that sort of stupor of denying bail after bail after bail, he did grant Jose bail, and because of that, Jose was able to get the charges dismissed. He's now out on the streets, back at work, living his life, trying to go through the process of rehabilitation like so many other people we know. Everybody deserves that chance to be heard and to present that evidence and to be treated as a human being instead of thrown into a cage without a second thought. And that's what happens under our probation system. And I also want to say that, yeah, people on probation have records. That doesn't mean that they should be assumed guilty. Like you said, Senator Archambault, the standard of evidence is incredibly low, unfairly low. It's very unjust. And it's dehumanizing to treat people as though they are already guilty. Every single one of us is capable of change. That's the point of probation. It's a period during which people are working really hard to turn their lives around, and I see people doing that every day. David, I don't know where he went, but David is not an exception. David's not an exception. Like we have countless people coming through our organization every day, and honestly, it feels very unfair to characterize David as an exception when I know so many people who are working so hard to turn their lives around. And I also want to echo again what Ray said about the fear-mongering. This idea that we can hold out somebody's name or pull out an example of somebody who committed multiple offenses, and then the idea that this is evidence that now we should be sort of having a blanket statement around anybody who is charged with a crime of violence.
And your 4 minutes is up. Thank you.
Can I wrap that up, please?
I'm sorry?
Could I just wrap up what I'm saying?
Your 4 minutes is done at this time. Yes, Senator Archambault.
Yeah, thank you for your testimony. Very articulate. You're passionate about it. I get it. I agree the system needs to be revamped. Don't look at me as the guy who's over here defending the system, because all of my words have been contrary to that. I'm focused on one aspect, and my question to you is, what about new offenders who commit violent crimes?
I think those people still deserve a chance to be heard. You should not be considered guilty before you're proven innocent.
Let me finish that. We're not talking about a chance to be heard. You're going to get a chance to be heard. There's due process inherent in the way it is now.
But is it due process to have somebody?
Excuse me, you don't.
Let me finish my question.
You have to wait till you're allowed to speak.
You get a lot
Yes,
of fire.
Senator Archambault.
Thank you, Madam Chair. You get a lot of fire in the belly. That's a good thing. I respect that greatly. You're very articulate. He is an exception to the rule, by the way. I'm going to double down on that. He should be proud of the fact that he is, because not many people make it that far. But when it comes to violent crimes, there's due process in the system when you get notice, you're in court, and then you get an opportunity to be heard. That's fundamental due process under the 14th Amendment Due Process Clause and the 5th Amendment. Notice and opportunity to be heard. And the question isn't about whether you're going to get your due process. It's whether you're going to be held pending that hearing, 10 days, 14 days. Technical stuff, no, give the person a chance. That's a way to help revise the system in the short run. It needs a better fix than just this bill. Even if this bill were to pass like it is, it's not going to fix the system. The system needs a better fix for the reasons you articulated extremely well. You really did. But beyond that, it's the violent crimes. It's new violent crimes. Not somebody who had a violent past and commits a minor offense. That person shouldn't be held accountable for the violent past necessarily. You look at the current crime. And in my practice and experience, that is what you see. I asked you about violent crimes. Simple
Could
question.
I respond to that?
Yeah, a simple question. They
So-
commit a new violent crime?
Point of order, point of order. I mean, just point of order. The way this committee works, respectfully, is we get to speak, and if there's a question posed to a witness, the witness can answer the question, and everything should go through the chair.
Thank you.
So you have to wait. Thank you, Senator Lombardi. You have to just wait for me to finish. So my question to you is, if there's a violent crime that's committed, a new violent crime that's committed, do you feel that the person should likely be held pending an outcome of whether or not they committed it?
Now you may answer.
So what I would say is that, first of all, if the person has committed a violent crime, they can be held without bail on the charge. Not that you don't need to wait for them to be held without bail on the violation. Second of all, the bail can be set as high as the judge thinks it needs to be set. If somebody has committed a crime of violence and that the judge considers that person a risk given their record, the number of times they've been cycling in and out of the courthouse, the judge can set the bail prohibitively high. That is an option. But I think at the end of the day, like, nobody should be sitting in jail during this time period waiting to simply be heard when they may be cleared of it. And that does happen frequently, that people are cleared of it.
Ken, let me just finish it with this.
And now they've lost this time. They're never going to get that time back.
I won't. Let me just finish.
They're not going to get that time back with their children. They're not going to get their housing back.
Let me stop you. I'm going to end it with this. I think I get what you're saying, but you missed it. I know that they can hold without bail on a new violent crime. I was talking about on the violation itself. If the violation is there and there's a propensity for violence and there's a new violent crime, the judge should be able to hold the person. Under this bill, you can't do it. It's crystal clear. You could just have gotten out of law school and you'd be able to see that. You're not hearing me. Anyways, thank you for your test. I do appreciate it. Very passionate.
Thank you. Next is Brandon Robinson.
How you doing today? My name is Brandon Robinson. I'm representing the Stop the Torture in Rhode Island Prisons Coalition. I served 15 years in prison. Before going to prison, I was a Johnson & Wales student. While in prison, I received my associate's degree, and I was a mentor figure teaching classes for over 7 years. Many people who worked on their rehabilitation got out of prison and was brung back for petty instances. For example, while out, somebody in a low-income neighborhood could get locked back up as a trespassing charge when they live in that same neighborhood, on that same street. And I hear you say that people get locked up for, like, without getting a crime, but this happens all the time in low-income neighborhoods. As well as myself, I'm on 22 years probation, suspended sentence. Somebody like myself or any other individual can get locked up for not keeping the peace in that kind of circumstances. And you might try to explain this to an officer, but they're not trying to listen to that. And then you find yourself locked behind bars, where I've seen many people who got out after doing a long sentence, got a job, got an apartment, got a car, established a relationship, established ties in the community. All of that was ripped away just because an officer didn't want to listen to what they said, just because of who they were in the past. And so in a low-income community, you can be locked up without committing a crime just because of who you are, where you live. And that happens all the time, and I've seen it many times. And I've helped many people while inside and while outside. Now I try to help youth as well to avoid these circumstances as well. And with these campaigns and these testimonies, I'm trying to help other people as well. But, you know, like you're saying, people do get locked up for no reason, for not keeping the peace, supposedly, and for trespassing, supposedly. That's my testimony.
Thank you very much for your testimony. If there are no questions or comments, we'll move to Mike Delauro now. Welcome. Does anyone have any questions for Mike at this time on this bill? Very good, seeing none at this time. Thank you all for your testimony. Next up will be Juan Turbide. Nick Horton. Do we have Nick Horton? Deborah Harris. Do we have Deborah Harris? Okay, thank you. Alex Morales? No? Okay, once again, if you would kindly state your name and if you're representing an organization, and just a reminder, you have 4 minutes for your testimony. We'll begin with, is it Juan? Yes. Make sure the button's up. Thank you.
Hi, my name is Juan Turbides, and I'm here. I'm the communication specialist at DARE. I'm also a member of the Behind the Walls committee that helped draft this bill. I'm on 10 years probation for possession and delivery of drugs. I grew up in a single-parent household with no positive role model and little to no opportunities. I just want to say I actually did 4 months for trespassing because I was on probation, and I know people that was incarcerated, beat the charge, and still had to do violation time, which makes no sense. I feel like probation is a trap. And they automatically lock you up for violations, and you could lose your host, your job, and you could use like a lot of things, and yeah, that's all. Sorry.
Well, we appreciate your testimony and your personal experience. Senator Archambault.
Yeah, your testimony may have seemed short, but you hit a nail on the head. You said something nobody else said, and it's a critical piece that needs to be fixed in our current violation hearing system, and that is that somebody could actually be accused of a new crime, right, whether they're held or not under this bill, and then ultimately found not to have committed that crime. The voice that says locked up for no reason, right? You're locked up because the officer says you have probable cause, whether they lie or not. Maybe the officer is telling the truth, lying, good and bad in society. But ultimately, that charge is unfounded.
Yep.
Yet you're still, that's the problem. That's the problem 20 years I talked about. That needs to be fixed. This bill, the way I'm suggesting adding to it or keeping it as it is, won't fix it. That needs to be fixed. That, you hit a nail on the head there. That shouldn't happen. It happens. That's the biggest flaw in the system. I appreciate you pointing that out.
Okay.
Thank you.
I just want to say it does happen.
Thank you.
It does.
Nick Horton, you're next.
Sorry. My name is Nick Horton. I'm the co-executive director of Open Doors. I started coming to this committee probably around 2005 and worked on a piece of legislation that I believe passed in 2010 to address this problem. Working with many of the people in this room, we passed a piece of legislation which specifically changed the laws that Senator Archambault addressed just now to make it possible or required for people who have their charges, who are found who are acquitted on charges to be released, to require those releases. It was a approximately 6-year-long battle. The legislation was passed by Senator Metz and Representative Siegel at the time, with the support of a former Attorney General and broad support across the state. I mention it to say first that we did successfully, I believe, cure one of the most egregious examples of this problem. However, we fought for years and convinced many, many people that that legislation would address their concerns. And I remember sitting here when a man named John Prince cheered when the Senate passed that legislation years ago, when this committee passed that legislation years ago. I think it was 2008. And the sad part is that John's, the incident that happened to John many years ago at this point would not have been helped by the legislation that we passed. Unfortunately, like so many others, John did not have the opportunity to take the charges against him to trial and beat them because he was forced to stay in prison for months after months without bail until he eventually was forced to plea to a crime he did not commit. And when I say he didn't commit it, I mean I have spoken to the person that committed it, who has since confessed. It was a improper identification. So it's extremely sad that we have to be here after so many years of fighting, and we're here not because this is the first solution or the imperfect solution that has been brought before the committee, but because it's the necessary solution that's been brought before the committee after so many other attempts have been incomplete. And so I ask you to find a solution that could be finally a reprieve for a man such as John, who was forced to spend 4 years in prison for a violent charge. It was a breaking and entering charge, which he did not commit, but unfortunately had no remedy for.
Thank you. Thank you for your testimony. Any questions? Yes, Senator Archambault.
Yeah, Nick, I'm aware of that legislation, and I understand the fix that was passed under Metz and Siegel, but the problem is the system still doesn't recognize that. So we need, that was a great step in the right direction, but we need a broader change that, and I don't sit here with the answer. I've had a lot of thoughts, and I've talked to you about this stuff in the past. Something that changes it so that in real time, maybe you don't even get the hearing. Maybe the hearing's expedited. You know, there's got to be a solution that enables one to accused of new charges to have that vetted with due process super quick. And if they're innocent, they're not held. You follow me? There's got to be some solution. The problem I see with this, I've already voiced enough, so I won't dwell on it, but you get my point.
Thank you. Next is it Alex?
Yeah, Alexis.
Alexis, I'm sorry.
It's okay.
Yes, if you could state your name in full and who you represent, and you have 4 minutes.
My name is Alexis Morales, and I'm representing DARE and Behind the Walls Committee. And I'm actually reading a letter from a Rhode Islander that is actually organizing in Louisiana now, working with formerly incarcerated folks. So his name is Bruce Riley. Dear members of the Judiciary Committee, my name is Bruce Riley, and I have been on probation for the past 12 years. This followed 5 years of parole, which followed 11 years, 8 months of prison. The sentence I received for my actions as a 19-year-old has stayed static. While I have changed considerably, prior to prison, I had been a foster child, homeless kid, drug dealer, and a bicycle thief. But that was 30 years ago. Today I am a good father, a good neighbor, a deputy director of a nationally recognized organization with 24 staff. Over the course of this journey, I have had at least 24 probation or parole officers and spent somewhere close to 1,500 hours reporting to them. I have paid over $10,000 in supervision fees, including paying for electronic monitoring in the first year of my release and submitting to countless drug tests and home visits. I am now subject to the Interstate Compact on Adult Offender Supervision because the Rhode Island Department of Corrections keeps me on supervised probation. This means I am the only person on probation in Louisiana for a term of over 5 years, and nearly everyone in this state is on probation for just 2 years. Louisiana has learned what all the studies have proven. Recidivism happens early on after release, if at all. And probation terms are best used as a temporary status. A few years ago, a political candidate for judge accused me of stalking her, and I got a restraining order placed upon me without any sort of hearing. When my lawyer contacted her to try and dismiss what some saw as a political stunt, she called the police and got an arrest warrant upon me, claiming I violated the restraining orders. Being on probation and being out of state, I would have 2 mandatory holds placed upon me. Fortunately, by the time the police confronted me at work, I had been using my legal network to handle the matter. With her being a member of the bar and me being a person with a criminal history for 3 decades ago, this legal saga took over a year to resolve. Not everyone is so lucky as I was to stay free, nor will many eventually win an $8,000 judgment against their wrongful accuser. SB 2373 addresses a long-standing problem of flimsy accusations turning into life-altering detention for people who are under supervision. If someone is, in fact, accused of a serious charge and there is tangible evidence to support the allegation, they can certainly be held for a long while and or released on a high bond. But for years, people have lost jobs, relationships, apartments, savings over the automatic probation hold triggered upon arrest, like fish that get thrown back. There needs to be some regard for damage caused by the process. Back when they had the warrant out for me, I couldn't turn myself in because I know how often people who work for the system said, "I'm sorry, there's nothing I can do." In good conscience, I could not, as a single parent, abandon my 10-year-old daughter to go on a quest for humans to override a system they manage. Every night I went to bed, I waited dreadfully for a loud knock on the door. Please pass SB 2373 because both my daughter and I need a system where we can have confidence that rational thinking and fairness can override automated incarcerations. Sincerely, Bruce Riley.
Thank you very much for your testimony. Any questions or comments? Seeing none at this time, thank you for your testimony. We skipped over Trent Manning and Ron Doyle. I had called them out to come up to the table prior, but we missed you. Are you Trent or Ron?
Trent.
Trent, come on up to the table. And is there a Ron Doyle? Okay, very good. This is our last witness on this bill. You may proceed. You state your name, if you represent an organization, and you have 4 minutes.
My name is Trent Manning, representing DARE and Behind the Wall Committee. Basically, I guess I just want to say a quick story about my personal experience. When I was 17, I was with a few friends, and I could say we was joyriding in his mom's car. So none of us are having a driver's license at the time. So I find myself behind bars because I believe at the time President George Bush had passed a law saying 17-year-olds were now being treated as 18-year-olds. So this was, 2007, 2008? So I find myself in the ACI at 17. I find myself confused. I find myself lost around all these grown men. You know, thankfully, I didn't have probation. So I did just spend a weekend. So we're gonna skip forward 2013. I find myself behind bars again. This was, I know you hear this all the time, this was not me. This was a mistaken identity. It has later been proven, and I'm still wondering if I could actually go for something civil about this. I sat there for about 6 months because I was out on bail for driving without a license. I sat there for about 6 months. I switched two private lawyers, switched from a defender to a private lawyer. Lawyer I had at the time was, he was old and he was, what's the word? Just losing his mind. So I switched to a younger lawyer. So that just kept me there for 6 months, and I was held for this amount of time that I just won't get back. An intake at the ACI. I lost my job. I lost, at the time, my girlfriend. I lost opportunities I had going for me, you know. I was in CCRI at the time. How do I explain all these things when I come home now? How do I explain all these things at the time I have my daughter with me? She was just being born. Do the timeline, this is 8 years ago. She's 8 years old right now. So that's just from my personal experience, you know? And now today, I can say I have been in the clear. I have kept a straight and narrow path, and I own my own business that caters to formerly incarcerated individuals. And I have someone that just, a worker of mine, just got out a couple months back. He has a girlfriend, spiteful tendencies, spiteful nature, whatever the case may be. He wants to better his life. He sees that she is toxic. He wants to leave. She is not going to allow this. What can she do? He's on probation. He's on parole. All she has to do is call, and that is what she did. Disturbing the peace, domestic. Now he is locked up. No, actually, he gets a warrant. Everyone knows he's on a straight and narrow path. So the lawyer calls him, the clerk calls him, they're like, hey, you have a warrant. We're looking out for you. Come and turn yourself in. I connect with DARE to help this process go through. I tell him, hey, you don't want to get caught in the streets. It's going to look bad. We're going to turn yourself in. 5 o'clock in the morning, we're going to be there for support.
Thank you.
Can I finish my story?
Not at this time. You can submit additional testimony handwritten unless we have one of the committee members who wants to ask you any question. Yes, Senator Lombardi.
Can you tell me how that story finishes?
I will.
Thank you, Senator Lombardi.
Thank you, Frank. I seen you was interested. I was
By the
on,
way,
on your behalf.
I'm just going to tell you, had you wore a Red Sox hat, you were never going to get that courtesy from me.
You may finish.
So, has everyone got the popcorn ready? So basically, we're there with him. District sees this is all just buffoonery, you know what I mean? They gave him the bail and surety, sent him off to Superior. He has, I believe, 10, maybe 5 in Superior. I could be, misspeaking. The judge at the time, he's just going through the motions. Deny, 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 you know what I mean? You do your 12, you do your 10 days, we'll see you back for a bail hearing. We'll see you back for a violation hearing. Deny, 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 deny. We'll see you later. You know what I mean? I gotta go. I got stuff to do. If it was not for my friend, my coworker, if he did not speak up and advocate for himself, he would have been doing 60 days right now, 90 days, easily. And the girlfriend actually spoke up also, saying, I fabricated all this. I didn't know this is what happens. I thought this was just going to be a weekend. I thought this was just going to be something where he just wakes up, he gets the cuffs on him, and then comes back home, and he's on good behavior. If he did not advocate for himself, he would not be here right now. He would have lost, opportunities.
Thank you, and we appreciate your testimony.
I appreciate it, Cynthia.
Any other questions or comments? Thank you very much. And that concludes the testimony on Senate Bill 2373.